NACDL is the association of the nation's criminal defense bar.
Hi everyone, my name is John Albanus. I am the Resource Counsel for the DC Compassionate Release Project. And this week we are discussing compassionate release vaccines and COVID positive clients. We've gotten a number of questions from you in both the federal and the DC project on these topics. And so we're joined by a number of esteemed guests this week to share their experiences with litigating these cases. And we're also joined by a medical expert who will share the science behind these often tricky issues. So without further ado, I am going to introduce our speakers, and then we will jump right into it. So Joanna Perales is a research and writing attorney with the DC Office of the Federal Public Defender, and she's been there since 2016. Her colleague Ben Flick is a research and writing attorney for the same office. He's been there since 2016. He was first in the Eastern District of Washington, and now he's in DC. And prior to that, he worked for the Mid-Atlantic Innocence Project and clerked for the Honorable Alan Kay in the U.S. District Court for the District of Columbia. Harini Raghupathy, I believe I got that right, is an appellate attorney with the Federal Defenders of San Diego since 2010. She earned her BS from Stanford and her JD from the University of California, Berkeley. Before moving to San Diego, she clerked for the Honorable R. Guy Cole for the U.S. Court of Appeals for the Sixth Circuit in Columbus. And then she worked as a Skadden Fellow at the ACLU Immigrants' Rights Project. Adrian Madsen is a member of the DC Superior Court and DC Court of Appeals Criminal Justice Act panels. He has litigated numerous motions for compassionate release under DC Code and appeals from denials thereof. He currently serves as a CJA panel's liaison to DC Superior Court for compassionate release issues and is humbled to have helped clients safely reunite with their family and friends. Prior to joining the panels in DC Superior Court, he was a supervising attorney at the DC Law Students in Court before later becoming the director of its criminal defense clinic. And last but not least, we are joined by Dr. Raymond Skolatar. He's a clinical professor emeritus of medicine at the George Washington University School of Medicine and Health Science. He's a master at the American College of Rheumatology, and he's a distinguished fellow at the American Psychiatric Association. That brief intro doesn't do his full CV justice, but for time constraints, I had to pare it down. So with that, let's jump into things. The format of this webinar is we're going to have each of our speakers talk about how they're handling these various issues in their cases, and I'll briefly talk about some of those cases as well. And then the good doctor will share his medical expertise. And once everyone is done, we're going to open it up to questions and answers. So with that, I'm going to hand it over to Joanna first. Joanna.
Thank you, John. Ben and I are going to tag team, and Ben is going to start off.
Okay.
Hi, everyone. Yeah, Joanna and I work together, so we'll be talking about these together. The issues that were presented to us to talk about were essentially, what do you do with your compassionate release cases when you have a situation whereby your client's been infected before and he's recovered, or what do you do in response to the government's arguments that vaccinations are on the horizon, they're coming any day now. The third one is, what do you do when your client has received one dose of the vaccine or two, or sometimes two? And then fourth, what do you do when your client refuses to take the vaccine at all? So I won't pretend to have perfect answers. What I can share are what we've experienced so far. I'd be interested in other people's experiences in terms of if anything's had success. Some of our arguments that I'll give are ones that have had success. Some haven't. A lot of times it depends on the judge, but I'll kick it off with, I think, talking about reinfection. Like what happens with a client who has been infected? You open up the case file, you're looking through his medical records, and the Bureau of Prisons or whatever medical records say he's been infected on such and such a date. With our experience so far, it seems to be the case that most of our clients have been infected. I looked at the Bureau of Prisons numbers today, and just what's reported is approximately 40% of folks. And that's, people have been doing this for a while, know that's likely a substantial undercount because there's just not enough testing going on. So what typically happens, obviously, is that the government will say, your client's been infected, he has all these medical conditions that CDC recognized are risk factors. He is at risk, we agreed with that, but it's now a tough question because he's been infected, so he's recovered, and his motion is now appears to be moot. And the arguments that they're making are that he has developed immunities, or that he is no longer at risk. I'd be interested in what Dr. Ray has to say about this, but the arguments we make is the first thing I typically will do is try and put in the human element, and I go through the Bureau of Prisons press reports, which just belie the contention that people are no longer at risk. If you look at the press reports from the Bureau of Prisons, it's a morbid list of everyone who's died in the Bureau of Prisons custody from COVID. And included on that list are a lot of folks who've been reinfected. And the way I'll share a screenshot. The way I find this is I just type in Bureau of Prisons press release in COVID, and then I'll see if I know how to screen share here. Let's show it real quick. This is the press release that the Bureau of Prisons reports, and you can see this is one example of many, but when you comb through them, you can see that this person, Ricky Miller, he tested positive on June 1st. The Bureau of Prisons says on July 6th, he tested negative, and then he later tests positive, and then he later dies in September 17th. That's what the highlighted sections show. So usually my briefing, I'll just go through each one of these I can find and just say that the government's proposition that you're no longer at risk is just belied by all these press reports and all these deaths that have occurred in Bureau of Prisons custody. I've seen 9, I believe. There's more than that. I'm sure that they're going to keep coming throughout the coming months. Then the other thing that we typically will go into is just the research. The CDC itself says that reinfection is possible. Right now, it's just uncertain. My understanding is how much we know about how long immunities last, and how protected we are. Some studies have shown that if you have a mild case of COVID or you're asymptomatic the first time, it means that you've developed less immunity. So later on, you're more likely to get it than someone, say, that suffered from severe COVID the first time. There's some medical journals that published it. I believe it was the New England Journal of Medicine that said that someone's antibodies rapidly decay in 90 days. So the medical research, I think if you look at it, it's just showing that it's very likely that even when you get it, you can get it again, that's proven, but it doesn't seem to be like that long of a period. The government will come back and say it's rare. And to the best we know, it's a little, it seems to be the case that it is rare, but then at the same time, all the clinical studies that have been performed have not occurred in a prison setting. So it's hard to actually evaluate the data when you know that prisons are just probably the most at-risk places. And the other thing I'll just note is that there's a growing string site of cases where you have folks who have recovered and then been granted compassionate release. That's in both the federal court in DC. I've had cases, Joanna's had cases, and that have spread across the nation in Maryland as well. So if I open up a case file and I see that the person's been infected, that doesn't dissuade me. I think there's lots of arguments to be made, and they've been done successfully. So I will note, if you have these kinds of cases, it's not a slam dunk, and it will be an obstacle, and the government's going to make its arguments, you make yours, and courts are somewhat divided. But I think, at least in DC, in our courts, a lot of judges have been receptive to these types of arguments. So if I saw that someone had risk factors and they've recovered, I wouldn't have that dissuade me in any way from filing a compassionate release on their behalf. Anything to add to that one, Joanna, or I'll move on to the...
Yeah, I just wanted to add one thing, and I'll talk about this more. The fact that the webinar is happening on today is good. For me, I had a hearing on an individual who both has COVID and refused a vaccine. And so it was helpful to flesh out what issues the judge was interested in. And one thing that I noticed in the hearing, and I've noticed in the other ones, is that you're going to have judges who believe and find that if the science is, I don't want to say inconclusive, we know reinfections happen, we just don't know how often. There's going to be judges who then err on the side of caution for your defendants, for your clients. And then there's going to be judges who err on the side of, well, it's your burden. And since it's your burden to show that it can happen and we don't know how often it happens, then you can't prove it. And that's a way of thinking that I don't think we can change that. And it is just the way your judge is going to approach it. And there are still arguments to be made, but the judge I happen to be against, that was his position. Well, we don't know that reinfection is going to happen to your client specifically. Ergo, there is no ENC, or sorry, extraordinary and compelling.
And someone made a comment on the side, and I agree with it wholeheartedly. The last thing I'll add to the reinfection issue is, if you have a client with lots of different medical conditions that they need regular medical care, putting aside COVID, even if they've recovered and they're not going to get it again, if they need regular care and the hospital is overwhelmed or the prison medical staff is overwhelmed, it's likely that they're not going to be getting the adequate care that they need, and just their continued incarceration is only going to create the need for it. So even if, I think there's strong arguments for that, or compelling arguments you can make that it's possible that they get reinfection, they're still at risk from getting it a second time. I think there's also arguments that even if you put that aside, if they need regular care, it's unlikely that they're going to be getting it in the COVID context and the era that we're currently living in. The other argument that frequently comes up that I'll share my experience with is that the government will say, kind of in the same paragraph, that they've been infected, or if they haven't been infected, they'll say vaccines on the horizon. It's coming any day now. Bureau of Prisons has given all these vaccines away, and they don't give any timeline whatsoever on when your client will receive it, but they insinuate that could be any day now. And the arguments I think we've done to counter that are essentially that there is no timeline whatsoever. The policy from the Bureau of Prisons is that they're going to vaccinate the staff first, and then whatever leftovers they have, then they'll do it to the inmates. But they, to my knowledge, have no idea when an allotment of vaccines are coming to the prison. They don't know how many they're going to get. So it's all very speculative at this point in time. And I think we've kind of touted that. And I think judges have questioned often, like we've had cases where the judges have asked if the government knows exactly when the person will get vaccinated. The government always tries finding this information out to use against us, but if they can't provide it, then the judges have been somewhat in agreement that's a bit speculative at this point. The other arguments I add to that, and I think Joanna will touch on this more in terms of what happens when someone gets a shot or one or two shots, I'll usually add to the fact that it's so speculative, there's no timeline in place, we have no idea when it's going to come. I'll add in addition that there's a lot of questions about the efficacy of vaccinations in the prison setting, meaning again that we didn't have any clinical trials take place in a prison setting. We don't know how effective it'll be for certain people in subpopulations. We know, for example, with influenza, in hepatitis B, the vaccinations were quite great and effective for those across the board, but for some people who are immunocompromised or that are obese, a lot of times those are types of populations we're working with. They weren't as effective, and so there's those issues, and also there's new strains that we're always concerned about on whether the vaccines are going to be able to protect against those. So the two arguments I typically make are one that just completely speculative at this point on when he's going to get it. The government says it's on the horizon, but we don't know how far away that horizon actually is. And secondly, if they do get it, we don't know how effective it is. I think the first speculative one is the stronger argument. But with that, that's all I have on that section. Unless you have anything else to add, Joanna.
No, not on that. So I'm going to address your clients that have received either 1 or 2 shots of the vaccine. So what we found by now is that the government they will go to the institution and ask for this information. And so it is not something that you are going to be not knowledgeable about. Either you'll know it from the medical records or they will know it from the medical records. They are documenting it, or they're asking their case manager or their counselor. This obviously does weaken your case. There's no way to get around that. Judges are going to say, that they're going to feel that this is the exact reason that I would have let them out, is to protect them from COVID. And now they've gotten a vaccine that can protect them from COVID. But again, there still are good arguments to be made. So one that we've been using is that there was a study. Now the studies, again, this is all happening in real time. So different studies are coming out at different times, and I'm, trying to use the ones that seem both accurate and helpful. But it did say that this was for Pfizer, and it was after 1 dose, it took 2 to 3 weeks to be 57% effective. And so there's some period of time, briefing takes a while sometimes, so I can't say for certain in any one case, but I did have a case where, the case that I'm talking about today, the time he actually got, that he got COVID was within that 2 to 3 week period after he refused the vaccine. And so there was some ability to argue, well, if he'd gotten it, there was still a period of time where his antibodies might not have, become as effective, as large as needed to stave off an infection. And then it said that this study on Pfizer also said that it took 2 weeks after the second dose for the effectiveness to reach that 90% range that we've heard about. So there's some wiggle room in weeks that I have used. And I don't know how many people remember this from the January 6th events, because there's a lot that's overshadowed it. But on January 6th, there were Congress people who had gotten their first doses and then got COVID from sheltering in one of the rooms near the events. And so that, I don't think our clients know that story specifically, but it can help boost the story that they do know, that is circulating through the prisons, which is at Fort Dix, which is one of the worst prisons for COVID, and many judges are realizing that now. There was a unit that all took a dose of the COVID vaccine. They all took it, and then within days they did test positive for COVID. Now, on the outside, we might understand that that's possible, that we understand why, but in the minds of the clients that I've spoken to, that to them suggests that it's not actually all that helpful, okay? And so that is also something to use as well. There is this time period where you're not as protected. The other issue for those that you can raise for those who have taken a first dose or a second dose is the strains that Ben brought up. And so there's really increasing evidence from Brazil, South Africa, the UK, New York, California, and there are many news reports about these strains that are giving proof that individuals have received the vaccine and still gotten COVID. There's an individual at Metropolitan Detention Center in New York who got the first dose and he died of COVID. And so these are they're anecdotes, I guess, but they're truthful ones that are in the news that you can use to show that you're not fully protected. And the other issue around these strains is that obviously the strains themselves are worrisome, but it's also the timing of, we're saying, well, there may be a booster. Well, okay, but then when are they going to get that booster? If we don't know the time frame for getting the vaccines and they've gotten 1, they've gotten 2, when are they going to get the booster again? And so it prolongs the fight towards protecting them. So The next about the vaccines themselves is that you can both argue that they are still an issue for these individuals, but the other factor that Ben raised is that if their risk factors are not just COVID related, so that they have a pre-existing need for medical treatment, you can still argue the inadequate treatment as an extraordinary and compelling circumstance. And then there's also, I've had judges who sort of take, whether there's an extraordinary and compelling issue, and if they found that, regardless of whether, so if they find that somebody has health conditions and it could raise their risk, even if they've had the doses, they then jump right to whether they should be released. And so there's judges who are just going to say, well, you might have had the vaccine, but we don't know that protects you fully. So I'm going to go on to considering whether you've done enough of your sentence, and then they'll decide you have. So that's a good thing. Now, getting to the refused vaccine. So again, there's no getting around that it weakens your case. It's a real hurdle. I hope that we can all be understanding and really try to get inside the minds of our clients of why they would feel this way. I think it is based on a lot of truth and a lot of fear that makes a lot of sense. But then we have to educate our judges. In any one case, I don't know that the judges will go with us, but if they hear it enough times, I think they will understand what the basis for this is. So our clients have gotten this sort of haphazard medical care and just a whole cascading of errors throughout the whole pandemic. It is looked, from the outside, it's looked awful, right? And from the inside, it's felt awful. And so they're now being told by the same people who aren't treating them very well that, hey, let me put this shot in your arm. What do you think? And they do not trust them. They do not trust them to store it properly. They don't trust them to administer it properly. They're also concerned that if they have an adverse reaction, that they'll just be left in their prison cell to tough it out, because that's what happens when you have COVID at this point. You're left in your prison cell, nobody's helping you, and you have to knock on the door for hours to get any care. And so these concerns are very legitimate. Staff are also refusing the vaccine for the similar reasons, same reasons, different reasons. We don't all know, but when the staff members who are able to go out to the outside, are able to read newspapers and watch the news, are saying, I'm not going to take that thing, there's no reason our clients should trust it. There's also the historic mistreatment of both minorities and prisoners as medical subjects, as patients. Racism is endemic in the medical profession, just like it is everywhere else. And so for individuals that have felt like they're not treating their concerns well in prison, for inmates to then turn around and just trust them is going to be difficult. Prisons also haven't been doing a good job of education at all. They have been, what they've done is they hand them let me see where we're going with the name of it. I'm sorry. I guess I don't have it here. Anyways, but they give them the fact sheet. And the fact sheet is provided for both Pfizer. I don't know what Johnson & Johnson's looks like, but for both Pfizer and for Moderna, there's a fact sheet. And the fact sheet uses words that say that the vaccine is unapproved by the FDA. It says that it is, thank you, John, that it does not help. So if you keep going down, it may not protect everyone. If you go up a little bit, John. So there's the line that says the Pfizer-BioNTech COVID-19 vaccine may not protect everyone. And then later it says, if you go down a little, it says that the Pfizer-BioNTech COVID-19 vaccine is an unapproved vaccine that may prevent COVID. And then if you keep going there's no FDA approved vaccine. And when you go down, it spends significant space on adverse side effects. There's no other place to get information. You're in prison. You're not going on the internet. You're not reading the New York Times. You're not reading the Washington Post. You don't know what an unapproved vaccine means. And this is all that has been given. Okay. And so these are the reasons that I think that we can educate judges on why it is that an individual would not take it. And this would be the reason that they should also not be penalized for not taking it. I can choose, with what I know, I am going to get the vaccine, but I could choose not to get the vaccine and stay inside my home and protect myself and others that way. They cannot choose that from where they are in their prison. And so that is all I have on the vaccine hesitancy. Ben, did you have anything to add?
Just two quick points. The first one is at least me personally, I plan to get the vaccine, but if I think back to when the vaccine first came out with the Trump administration at the time, where it was somewhat antagonistic towards science, and then there was talk on whether they're telling the CDC not to test people, that I personally, with the speed at which it came out and Operation Warp Speed and what have you, I was a little concerned, wondering, was this a politicized thing? Is this safe? Is this just, was it based on politics or was it based on science? And as Joanna was alluding to, all of us have access to the internet. All of us have access to the ability to get a lot more information about it and updating resources. So my initial intuition, which I imagine was similar to many, was first, is this safe? And then it's got this RNA stuff, and I had to look up how these actually operate. And then in prisons, there's where you can't get the information, and there's all kinds of misinformation being spread, all kinds of conspiracies, all kinds of rumors that just don't get corrected. When people hear RNA, they're wondering, oh, is this going to change my DNA? And they don't have someone who they can go talk to determine, by taking this vaccine, are you going to grow a new arm out of the right side of your body, or anything like that? And we've heard all kinds of other conspiracy theories, some rumors. We don't know if they're true, they're not. I think it was Fort Dix, people were saying that they're actually, the prison's not vaccinating them. They're actually giving them the medications that Trump took, but they're not actually administering vaccinations. I don't know the truth to that. I don't think it's true, but the bigger point is that a lot of folks on the inside just believe this to be true, and that information in that bubble, without it getting corrected, just leads to a lot of just decisions that from a judge might say, no, that's ridiculous, but where that's the only information you know, is just kind of difficult to kind of get out of that, or it's not possible in prisons to get out of that kind of space and determine what's real from what's not. So I think a lot of the arguments, I think that can always be reframed as, here's what they know, and then the inability to correct it. And then the prisons aren't giving much outreach in terms of like correcting this information. And a lot of prison staff are helping fuel some of the misinformation as well.
Great. Thank you both so much. That was very informative. I'm going to pass it on now to Harini to share her experiences litigating these cases out on the West Coast.
Good afternoon. I was going to say good morning, but I suppose for all of you, it's good afternoon. Joanna and Ben, it's nice to see your faces. I see your names all the time on the listserv. So I'll just jump off where Joanna and Ben left off. So I'm going to cover a lot of the same points, and I'll try not to duplicate anything they've already said. But I guess starting with clients who've already tested positive for COVID at some point, I would agree with what Joanna and Ben said. My office in San Diego, we don't necessarily see that as a barrier to seeking compassionate release for someone. Because at this point, a majority of the people who contact us seeking help have had a positive test at some point. And so I think one thing a strategy that we have developed that has had some success is to either use a generic declaration that we have developed with the infectious disease specialist at the University of California, San Francisco. Her name's Dr. Tara Vijayan. And she worked on a declaration that talked about why our clients in prisons are particularly susceptible to reinfection. about how, because of the nature of the prison environment and stuff that's a little bit beyond my understanding, but the nature of the viral load in prison, that people are more likely in a prison setting to be reinfected than they would necessarily if you translate that situation to the outside world. And so I don't know if that's a publicly available declaration. I'm happy to send that to John if to circulate. I don't know if folks have access to that, but that could be a helpful declaration to use. And then the other thing that might be worth considering if you have the resources to do this is to contact an expert in your specific case to opine on your client's specific vulnerabilities to reinfection. And so, I think we've had some times where we've used the generic declaration and the judge isn't satisfied because it's not particularized to our client. And so we've had to, contact someone and contact a doctor to see if they're willing to analyze that particular client's records and then provide a declaration that's unique to that client. So that is a strategy that we've found successful. And I'm going to try to share my screen for a second. But last week there was a good decision that came out of the Western District of Washington, out here on the West Coast, in a case called United States versus Sandoval, and that was a strategy that they employed in that case. So I'll just share my screen here. This is the order, and here's the case number. But basically what the strategy in that case was for the lawyers is they were able to contract a doctor, Dr. Robert Rakita, and he provided an expert declaration on why that particular client who had was taking medications that were immunosuppressant medications, why those medications rendered that particular individual more susceptible to reinfection. And so what the court found was that Sandoval has, through case-specific experts, made a showing that he has a different reinfection risk than the general population. And I think that's what the court particularly found compelling in this case. And so that might be a strategy to employ if you're able to, is to find a doctor who can talk about your clients, what makes them particularly susceptible to reinfection more so than the general population. Okay, so the other thing, I think Ben and Joanna touched on this briefly, but while we're on the topic of people who've already tested positive for COVID, the idea of COVID long haulers, I think, is also another avenue to explore. So apart from the risk of reinfection, people who have had severe COVID cases, they suffer, sort of symptoms that continue for a long time. So whether it's trouble breathing or just exhaustion, or, we know people out in, I have, acquaintances who still can't taste or smell 10 months out. So things like that, where, even separate from the risk of reinfection, just the continued medical sort of effects that they're suffering, that they're not able to necessarily get treatment for in the midst of lockdowns, in the midst of reduced access to medical providers right now in the prisons. So that could be another thing to focus on for people who have already contracted COVID. So that was pretty much what I wanted to say that Ben and Joanna haven't already mentioned on the point of people who've already tested positive for COVID. I think I'm going to shift now and talk a little bit about how my office has been dealing with the vaccine issue. And there's lots of things related to that. So I saw in the chat, there were some questions about numbers, and I don't want, at the risk of, sharing really basic information, I thought it might just be helpful to share the two sources of public information about the BOP's vaccine rollout. So there's the official BOP page with their COVID-19 vaccine implementation, and they'll have the doses distributed and the doses administered. And one thing to note is, on most days, the doses administered is going to be more than the doses distributed, because with the Pfizer BioNTech vaccine, I guess there's 5 doses per vial technically, but you can usually eke out a 6th. So if you're confused if this number is higher than that, like I was, that's why. These numbers, I think, should be taken with a grain of salt, just as we've seen from the infection numbers in the prisons. They often are suspect, but they're a good starting point, I think. And then the other official source of vaccine information is the CDC's page. And so this is for the whole country, But if you go down here with federal entities, you can hover over BOPs, and they'll also have information. You can also compare the two. Oftentimes there's a little bit of a discrepancy, but this is at least a starting figure for the doses that have been delivered and administered to various facilities. And in particular with the CDC or the BOP's information, I think what's helpful is they break it down by staff and then our clients, so the inmates who are inside. And then you can also find from the BOP the total number of staff at a facility and the total number of inmates. So you can sort of get a sense of percentages of people of the community at a particular prison that's vaccinated, which might be helpful and a helpful argument to make, because even if your client's vaccinated, if the majority of people aren't, there's arguments that could be made related to that. But I wanted to share those two sources of information that may be helpful. Let's see. So with the vaccine, the vaccines, one thing I think that's important to consider is one, just to get the facts right, because I've had at least a couple situations now where the BOP is claiming that my client denied a vaccine, and my client, when I spoke to him on the phone, said, no one came to me to talk to me about a vaccine. I don't know what they're talking about. And these were both situations that happened at a facility out in California called Lompoc. So I don't know if this is a particular thing at Lompoc. My guess is if it's happening at Lompoc, it's probably happening at other institutions as well. So I would double check with your client. All that to say is I think it's important not to take the prosecutor's word that your client has been offered the vaccine, or that your client has obtained the vaccine, or that your client has been denied or refused to take the vaccine. I think it's important to have that conversation with your client and to also confirm that the medical records support that. So what I wanted to show you is that discrepancy that I discovered with my client. So here is a medical record from one of my clients. And it says, if you look at the administrative note, it says inmate was offered COVID-19 vaccination on 12/31/20. Inmate gave verbal declination at that time. When we returned to obtain a signed declination, inmate refused to sign and stated that they had changed their mind and would like to receive the vaccine. So this is talking about a verbal declination. When I called my client on the phone and said, hey, what's up? Did you get the vaccine? What's going on? Or were you offered the vaccine and did you change your mind? What's going on? He said this conversation never happened. And so I think situations like this may be more common than we, are probably fairly common, and might be ripe for an evidentiary hearing if necessary. Because if your client, if the BOP is saying your client refused a vaccine, but your client is saying they never were even offered the vaccine, then obviously that's a fundamental factual dispute that needs to be figured out before you can proceed to any kind of legal questions. And so what I think you want to look for is this. So this is the COVID-19 vaccine consent form. And there's two boxes: I consent, I decline to consent. And then there should be your client's signature and then a witness's signature. So that, I think, is the best evidence the government will have about whether your client has been vaccinated or refused to be vaccinated. So if you don't have this document in the medical records, I think it's worth pushing back and having a conversation with your client about, what exactly happened. So I just wanted to share that, because I think even before we get to legal strategies, it's important that we're all, operating from the same set of facts. Just because the government says your client refused a vaccine may not actually be the case. So when we're talking about clients who have received the vaccine, I think our job as lawyers is to educate the judges about the difference between efficacy and effectiveness. So I think our judges are all reading the news and hearing that, that both Pfizer and Moderna have a 95% efficacy rate. And I think most of us, generally not being, statisticians, we think that means, okay, so of 100 people, 95 people are going to be protected or have, not get a sufficient response such that they have to go to the hospital, and there will be 5 people who will probably get sick. But I think what we need to do is unpack that and explain that more, that that's actually not what those numbers mean, that efficacy is different from effectiveness. So, and there's a good New York Times piece that I think I have used to understand these terms myself. And I can, I'll share that too. But it's basically, it might be a little dated at this point, but if you're kind of not totally understanding yourself what this means, it just says 2 companies say their vaccines are 95% effective. What does that mean? And then it kind of breaks down, it has different questions and explains them. So I think if to get your own head around that, that might be a good place to start. And then that could be, you know, a source of information you can use to educate the judges as to 95% is great. You know, I think we have to be careful. We don't want to say vaccines don't do anything because you'll alienate the judges, but you also want to explain there's a little more nuance there. And then the other thing I think that's important is to explain why your particular client's risk factors may make them, you know, not, even if they get the vaccine, it may not elicit a sufficient immune response to them. So I think, as Joanna and Ben talked about, vaccines, you know, haven't necessarily been tested on people in prison in those conditions, people of, you know, certain subpopulations like our clients who tend to be older, who may have lowered immune systems, who are obese, all of those types of things. And then let's see. I think the last thing I just want to talk about in the interest of time, I guess, are John had mentioned any advice about what we tell our clients about taking the vaccine. And I think someone had mentioned in the chat there's serious problems with informed consent. I think that's completely accurate. I've had several clients tell me, you know, a CO, a correctional officer, has just come up to me and shoved a piece of paper in front of me and said, sign this, do you want to take the vaccine or not? And it's, you know, they have to make this extremely important medical decision within 30 seconds. And then Joanna shared the, you know, information, the fact sheet that they're getting that, you know, a rational person reading that, I think, would have serious reservations about taking the vaccine, coupled with all the other things, you know, Joanna talked about, you know, people of color being distrustful of the medical system in general, and then our clients in prison being distrustful of the medical system. So all of those things. So what we've done in my office is basically, if clients ask us our opinion about taking the vaccine, first, we make a disclaimer that we're not medical providers and that all we can do within the scope of our practice is to explain how taking a vaccine or declining a vaccine will affect the compassionate release motion. That's sort of like the baseline. We're not telling you what to do medically, but if you take the vaccine or if you refuse the vaccine, it's just going to make your compassionate release motion harder. If you're offered the vaccine and you take it, you know, we still have arguments to make, but it's also going to make it harder. So just explaining the legal ramifications of choosing to take the vaccine or not. And then if they continue to have questions, there's 2 fact sheets that I think are very helpful. One is by the Amend Project at UCSF. And let's see. So this is Amend. It's a project at UCSD, or UCSF, sorry. It's about healthcare and correctional facilities, and it says COVID-19 vaccine information for residents of correctional facilities. So we have this document that we have translated into English, or that is in English, and then our interpreters in our office have also translated into Spanish that we send to folks when they ask us specifically about, you know, should we take the vaccine or not? And then just today, I saw the Marshall Project. Oops, I don't have a tab up, but the Marshall Project did a survey of people in prisons and jails and asked them what their questions were about the vaccine. And then they issued an explainer that answers those commonly asked questions. So I was thinking that might be another helpful thing to send to people who are curious about, you know, they want to actually have informed consent, if they actually want to understand what the vaccine means for them. And then just a final thought, I think it's important to think about pivoting as well, as, you know, vaccines are being rolled out and they are affecting the success of our compassionate release motions. What I've been trying to do is to sort of vaccine proof my motions moving forward by including extraordinary and compelling reasons that have nothing to do with COVID or the vaccine rollout. And so things to think about are, you know, regardless of the vaccine rollout, we're still in a pandemic, and the BOP is still on, modified operations. And if you talk to any of our clients, they have decreased access to their medical providers. And so a lot of our clients who have serious medical issues, they're not getting the medical care that they are supposed to be getting. So that's an argument you could make, the inadequacy of the medical care. And that has nothing to do with, that's independent of whether your particular client is vaccinated or even if the whole population becomes vaccinated. There's arguments depending on the nature of your client's conviction, the length of the sentence, and whether if they were sentenced today, that comports with fundamental standards of fairness. It's important to think about, your client's family circumstances. Are they a caretaker? Do they have caretakers for their children outside who've been affected by COVID and can't provide that care anymore? So kind of thinking, I guess, outside the box and thinking of ways you can raise extraordinary and compelling reasons that are not going to be susceptible, no pun intended, to the vaccine. So I guess with that, I will turn it back to John.
Great. Thank you so much for reading those. Very informative. So I'm going to turn it over to Adrian now, and then that should leave us enough time for Dr. Skalatar, and then we're going to end the recording and open it up to questions. So Adrian, take it away.
Thanks, John. And I'll be, I think, even more brief than Harini, trying not to repeat what others have said, even though my experience has been in Superior Court and DC Court of Appeals in terms of the issues related to strategy. Even though the laws are slightly different, I think the same applies. And in most cases, or all cases, that is, we are the opponent, that is the United States Attorney's Office, is the same. So the types of responses that we've been getting have been largely the same. I guess one thing that I would mention that I haven't heard mentioned is that at most Superior Court, to the degree that judges in Superior Court have adopted what the standard of proof is, they have mostly agreed that is a preponderance of the evidence. And I think that's an important thing to keep in mind and reiterate here, is that we're not proving beyond a reasonable doubt that our clients are susceptible to or face some acute vulnerability to COVID-19, that the standard here is a preponderance of the evidence. And so I think others can speak to the specific medical circumstances, but I would say with the vaccine rollout and with the possibility of reinfection, we don't need to take on a burden that we don't have, right? That of course it is our burden, but don't take on more of a burden that you have, would be just some strategic advice. And because there is understanding that judges in federal court have gone different directions on this. Some have said that reinfection, of course, moots out the claim. Some have said that it does not. Because the DC Court of Appeals has not given published guidance on this, they have not issued any public opinions. Many of the Superior Court judges are looking to federal judges and federal decisions for guidance. And having said that, where there is at least some body of law regarding reinfection in particular, that saying that does not moot out the claim, given that the existence of that fact and the development of new strains of the virus. So in other words, at the time of many of those decisions, many of those helpful decisions, we were talking about older variants of the virus, and we are now in a position of talking about newer variants of the virus and the possibility of reinfection. I think that certainly strengthens the argument. In other words, if there was the possibility of reinfection with the same variant of the virus, and that was sufficient to establish extraordinary and compelling circumstances, then the possibility of reinfection with a new variant of the virus, which there is, I would, at least from my understanding, more demonstrable evidence that reinfection occurs, and it's seemingly at higher rates than with the same variant of the virus again, then that strengthens that argument. The other thing I would add is that I've seen some recent studies just in the last couple of days about the efficacy of, or rather the effectiveness of vaccines broken down by subgroup of comorbidities. That is, for example, there was a study related to the effectiveness of the Pfizer vaccine in particular for people who were obese. And so that is, even if these are the overall numbers, as others have said, of course, your client's specific circumstances are important, but as the science continues to change, I would just continue to be on the lookout. I think I'll preface this by saying that I think all of our clients almost do face extraordinary and compelling circumstances, but I think our goal should be to create or focus on the uncertainty that does exist in the circumstances, and that itself should be sufficient to help with the extraordinary and compelling circumstances argument. I don't want to repeat what others have said, and I think that Dr. Scaletta probably has much more helpful things to say about this subject, so I will turn it over to him.
Thank you very much. A long time ago, I learned never to be the last speaker before the cocktail hour. So you've all covered so many of the medical aspects, so I throw away my paper. And I will just try to make some comments on what you have stated. First place, we do this work pro bono for the compensation, the release program, in case you didn't realize. If you're looking for attorneys, it does exist, and we've been working that way. Anyway, there have been 70 million doses administered as of 12 o'clock this afternoon, from what I've heard. And it has been extraordinarily safe. And there have been very, very few severe reactions, and which has been rather amazing. And this is from the leadership at George Washington, which just had a grand rounds on the entire process, and they're very familiar with the Moderna and the Pfizer vaccines, and that is the latest. And the recommendation is that everyone should be vaccinated, everyone. Now, we understand that there's a lot of people who do not want the vaccine, and the anti-vaxxers have been very successful in getting this across, and I understand that many people of color have had the rationale because of Tuskegee and other distrust of the government, the profession, what have you. But the recommendation is that everyone should be covered. And you're absolutely right. We do not have the final data on these vaccines. These were emergency use authorizations. And so whatever you read of any disclaimers, it's very, very typical. If you read the disclaimers in any of the medical drugs that have been approved, you'll see similar disclaimers that this can happen and that can happen. And so this is not unusual under whether it's emergency use approval of a drug, a medication, or a vaccine, or the final approval. So the Moderna and the Pfizer vaccines are these messenger RNA vaccines, which means that the spike protein from which is induced into the body can undergo mutations. And that is what is happening now when we're getting these variations. We are seeing mutations. And now, the issue came up about effectiveness. We all recognize that it's not 100%. If it's 95% in the Pfizer or Moderna, 60% or 50% with Johnson & Johnson, the factor is that everybody should be vaccinated. And the purpose of it is, even if it could be, of course, reinfection, the purpose of it is to keep you out of the emergency room, to keep you out of the ICU, to keep you from requiring a respirator and dying. And that we know it has definitely mitigated those problems. So we have no data, at least I have no data about prisons and reinfection. Many of you may have that, and that's something, but finally, the vaccines are effective. And I mentioned about the ICU, and we have been going by the CDC guidelines of increased risk and those who are of less risk, and we continue to do that. But I've also recognized, and someone has stated correctly, in many of the depositions, or at least the writing that I've done, the inadequacy of medical care in some of the facilities and how many of the prisoners have been put off for months with symptoms, and it's totally intolerable. We want quality health care for all our patients, but it is sorely lacking in the prison system. So that's about all I have to say, but I hope everybody gets vaccinated. Thank you.
Thanks, Doctor. And one of your colleagues, I believe, Dr. Cohen, you can correct me if I'm wrong, but he mentioned that there are some studies indicating that in individuals with advanced kidney disease, there is some kind of a wrinkle involving the vaccine.
Yeah, Dr. Cohen correctly stated that, and this exists for all vaccines, that patients with severe renal disease and those who have been on dialysis may have less immunogenicity. They may have less of an immune response, and their antibody titer may be less. However, and therefore it may be less effective in them, and they may be more vulnerable for reinfection. However, all authorities state that everybody, even those with severe renal disease, should get the vaccine.
Great. Thanks, Doctor. And we have a surprise guest speaker, in a sense. Steve Salke wanted to chime in about vaccine effectiveness, and I'm happy to give him the floor briefly before we turn it over to the Q&A. Steve has worked tirelessly with the Federal Compassionate Release Project as a sort of liaison to the medical experts that many of you have worked with. So Steve, go ahead.
I coordinate all of the physicians who do the consulting. Ray is one of those physicians who, on a pro bono basis, consults on your cases. And the science of vaccine effectiveness in a variety of subpopulations is very much a daily subject of research and development that is changing rapidly. So you really do need to focus on the existing medical conditions of your clients, and not just with end-stage renal disease, but again, most of this scientific research is being done in the laboratories to determine the effectiveness of the vaccine against the emerging variants. The emerging variants there are a variety of emerging variants, some of which are more contagious and more damaging. And we just don't know yet how everyone is going to react. And the population that was the population in the clinical trials is often very different from the circumstances that your clients, the medical conditions that your clients suffer from. So I encourage you I track it on a daily basis, and I try to provide it to the consulting physicians. And I encourage you to seek advice and expert testimony, as others have said, about, even when your client is vaccinated, about whether their medical condition still could put them at significant risk of COVID infection and a severe case of COVID, given their specific conditions. By all means, as Ray said, the vaccines are highly effective, and everyone should be encouraged to receive them. But even those that receive them, there will be cases, particularly for your clients, where they will not be as effective as they were for the populations upon which the clinical trials were conducted.
Yeah, I'd just like to chime in. Thank you, Steve. Thanks because I appreciate working with you. You've been wonderful in helping us and directing us. I'd like to say something about the variants, which we know a lot more about, particularly we know about the UK, Brazil, and they have these fancy numbers and B117, et cetera, and the South African strain. And this should not be any surprise that there would be mutations. And actually, we are probably going to need booster doses. As a matter of fact, starting Monday, Moderna goes into a phase 1 of starting booster doses, trials to give boosters. I think it's going to be similar to the way we have the flu vaccines every year, where we have different strains and we attempt to incorporate them into the current vaccine, especially here in the US, depending on what's going on in Australia and the other hemisphere. So yes, the variants are there, they're here to stay, and there'll be more, and we're going to have the vaccines with booster shots. Huh. Yeah, social distancing, I saw that one. Yeah, how do you do social distancing in the prison? That is, how do you do masking in the prison? Do they even have masks? I mean, the 3 W's: wash your hands, watch your distance, and and the masks. Wear a mask. It doesn't exist. How do you do it in a cell of 2 people? What kind of social distancing is that? The whole concept of prisons have to be thought out again.